Okay. Can everybody? All right. Whoa. All right. So am I online?
I'm just waiting on them.
I think we're trying to get going here. Is Setzler gonna? Is he coming back?
I thought so.
Okay. Yeah. Gullet, if you want to go ahead and we're good. Okay, this is the Reeves Subcommittee of Judiciary Non-Civil. We have one bill that is up for consideration today. It's House Bill 411. Just so that everybody knows, House Bill 327 was pulled off the calendar today by a lot of the parties that are involved, and the plan is to reschedule a hearing for Thursday afternoon on that. Although we are trying to secure a room right now, and apparently there aren't any rooms available, so we will be working through that. But so we're going to hear House Bill 411. I know that there are some folks out in the hall from the Prosecuting Attorneys Council and some, I believe, a DA and a Solicitor General who are going to testify, and also have Jill Travis from Gactyl is going to be joining us online, I believe. And I don't know if anybody else is intending to speak, but if so, then figure out a way to let us know. And with that, Representative Gullett, if you want to, why don't you walk us through your bill? And I want to be careful when I use the word painfully explain it to us, but make sure that we understand. Give us a good understanding of what we've got going here. And if you want to talk about the bill and why you're doing it in general, then please, the floor is yours. Let me get your, is it working now?
Yeah, there we go.
Okay, perfect.
Thank you, Chairman. So this is LC 41-2913, House Bill 411. It creates a Prosecuting Attorneys Oversight Commission. It creates a commission that has the power to discipline, remove, and cause involuntary retirement of appointed elected district attorneys and elected solicitor generals. Today in Georgia, there are 49 district attorney circuits, so 49 elected district attorneys and 66 solicitors that are elected in Georgia. It would only be for the electeds. It wouldn't be for the ADAs, and I'm not sure what you call a solicitor who works in the office.
Assistant solicitor.
Assistant solicitors. There you go. Commission would be divided into a 5-member investigative panel and a 3-member hearing panel. The investigative panel will be made of 5 members, 1 DA appointed by the governor, 1 solicitor appointed by the lieutenant governor, 2 prosecutors who have 5 years experience as a prosecutor, but currently aren't prosecutors. Doesn't have to be elected prosecutors, just worked as an ADA by the speaker, and 1 prosecutor, the same criteria, 5 years experience, but isn't currently working as a prosecutor by the Senate Committee on Assignments. The investigative panel would elect the chair and the vice chair, so they would elect their own chair and vice chair. The hearing panel is made up of 3 members, 1 citizen appointment by the governor, 1 district attorney elected by the full Senate, and 1 senior judge, and that's defined in here, Superior Court senior judge by the full House, elected by the full House. The district attorney on that hearing panel would chair the hearing panel. The commission would be tasked to write their own rules.
Where is that in tell me where that is in the bill.
Yeah, so if we go, sorry, on here. It's towards the back. So line 116,
Yeah,
commission with the assistance of prosecuting attorneys council, state of Georgia shall promulgate rules for the commission's governance. So 116 on. There are some guiding canons that those rules must cover. And those are also in the bill, line 126. It's really section H, so it starts at 125, but really there's 3 of them. Number 1, uphold the laws of the state of Georgia. That's on line 126, line 127. Avoid making extraneous judicial statements regarding pending litigation matters within their jurisdiction. And then line 129, number 3, avoid conduct that causes disrepute of the office of the district attorney or the office of solicitor general.
So tell me again so H is the
Those are kind of like
broad qualifier for what the rules would be. the rules and purpose and function of the commission would be directed at making sure and enforcing that elected DAs or solicitors did those three things.
That's right. Those are the
So those are the
canons.
boundaries of which
That's correct.
the commission would operate in.
That's correct.
Okay.
So that is the gist. It would start April of next year, would be the appointments would start from a fiscal standpoint. I don't have a fiscal note on this particular LC, but I have a fiscal note of a very similar LC. The fiscal note was driven really by how many cases that they would hear. So I don't expect it to change. It was like 900 and something thousand per year. But from a appropriation standpoint, we thought it best to start April of next year from the amended budget. And then in order to write the rules as far as this legislation is concerned, and then them beginning receiving complaints on July 1st, the new fiscal year. That's the gist of the bill, the high level, 30,000 foot level view of the bill. And I'm happy to deep dive, and I understand there's gonna be some questions and concerns, and that's the reason that we have a committee. I hope that we can work through this to make this a good legislation at the end of the day, and a commission that actually is tasked. I know I've talked to a number of bodies along the way. PAC has been involved somewhat in the legislation, talked to Robert Smith a good bit, and I appreciate his help. I've talked to a number of prosecutors, elected prosecutors or formerly elected prosecutors about the bill, and I talked to a formerly elected solicitor as well. So just trying to figure out, how we get this oversight commission, what it looks like, and how do we make it, one, do what we want it to do, but still allow prosecutorial discretion, which we definitely want. We don't want to remove that. That's not the goal of this bill. I think there's some misinformation that I've heard anyways, that this is what this does. It's totally not. It's really just making sure that there's a way to handle prosecutors who aren't handling themselves correctly today.
Is it safe to say that this is, although the structure of it is appropriately different than the JQC, but is this a similar function as far as the role of the JQC has with elected judges, or I guess appointed judges too?
Yeah, 100%.
That this would act in a tailored capacity that's more specific to prosecutors, but is that by way of analogy a fair analogy?
Yeah, and if I was explaining it to someone who totally is foreign to the world, that's exactly what I would say. It's a JQC version for elected prosecutors and solicitors.
Okay, and
although it is different, we did try to tailor it to, prosecutors and solicitors, realizing that judges have a different role.
mhm.
That was the foundation point, though.
Does anybody have any questions for the author of the bill? What number are you?
Mike, 15.
It's working.
Thank you, Mr. Representative. I wanted to ask you a question, and I don't know if you've gotten an opportunity. Have you had the opportunity to review the Georgia Bar Rule 3.8, which deals with the responsibility of prosecutors?
Yeah, I have, and I actually have it on my paper. I looked at it even today again. I have.
Now, and again, I understand the sensitivity of this topic, but if that rule was to be amended and I guess given a little bit more authority, would that not actually cover what you're trying to do in your legislation through the Georgia Bar, where the Georgia Bar can actually provide any type of disciplinary action to a DA that may be breaking the bar rules? It basically give a little bit more teeth to the Georgia Bar Rule, where we don't have to try to have a legislative oversight of elected DAs and solicitor generals in the state.
Yeah, good question. Thank you for your question. So I would slightly disagree to a degree in that the bar I think they have a tough time going after electeds in general. I don't think that's, although they have the authority, we have to figure out a way. What I don't want to do is I don't want to erode the bar's oversight into lawyers in the state of Georgia. That's not what we need to accomplish, and we need to make sure we don't accomplish that. The bar has a role to play and the Supreme Court has a role to play. So we have to balance those out. But I do believe a commission is actually needed because, one, the bar is put into a predicament where going after electeds is sometimes what this does. What we want to take out is the politics of everything. And sometimes when that happens, the reality is the politics plays a part in that. And that's what we do not want. Not to say that the bar can't do the job. It's just, I feel like they maybe aren't the right people, right person to do the job. Although they have the authority in 3.8, I think, to do that. We haven't seen that happen.
And let me ask you that on that point. I mean, I think that the elephant in the room is clear. There's been a series of isolated and unrelated incidents, frankly, across the state that have called into question, certain integrities. And tell me if I'm right or wrong. Has the bar been aggressive in seeking to address those?
Yeah, so I'm no attorney and I haven't followed this closely, but in the research that I've done, they have not been.
And I don't even know if this is so. Are you saying, Representative Bodie, that the bar right now is currently considering potential amendments to Rule 3.8 to give it more teeth? I mean, is that a fact? Are you aware of that as a fact?
Yes, Mr. Chair, and without going too in depth, it's actually a group of prosecutors who have created a task force where they're actually internally looking at 3.8 to give it more teeth. So it would be oversight where the bar can take more action than they are right now. So it is actually a task force that's meeting right now, have met, and looking to make a recommendation to amend 3.8 of the Georgia Bar Rules.
And I have nobody. I'm not aware of that, and I'd certainly want to learn more about that and get up to speed with what's going on with there. But I mean, some of these issues have been ongoing for a while, and and here we are with legislation, and now the bar is wanting to act. Is it too little, too late? And what reliance can we have? And obviously, there are people in here that can perhaps answer this question as we get through this hearing. But what reliance can we have that they're going to actually do so? We don't have any control over what they ultimately decide to do. And I'm looking at 3.8 right now, and I see that, the most that they can do right now is a reprimand.
Yes.
And obviously we're talking about things that go beyond, beyond the remedy of a reprimand is inappropriate for some of the things that we've experienced. And, I do not have the knowledge to intelligently speak about the timing of the bar's interest in this alongside the legislation, which has been talked about and we're looking at right now. But
Mr. Chair, may I follow up to your point? And I understand your position, Mr. Chair, because originally I actually had a DA oversight bill that was in direct response to the Ahmaud Arbery case. But when speaking with the DAs and the solicitors, they have stated to me that they are willing to increase the punishment above a reprimand and to make that recommendation to the bar. And they have stated to me that they need at least one more legislative session to get that done. So we are in a biennial situation where if we were to pause on this and see if the DAs and solicitors come together to actually implement this and the bar rule is passed in July of this year, then when we come back from legislative session, this might be a moot point where we don't actually have to legislate and create an oversight committee because the bar has already acted during their summer meeting.
And I understand and appreciate what you're saying. I think that had we done something like this a few years ago, then perhaps there have been some very unfortunate situations that never would have happened. That would historically not have taken place had there been a commission or a body that is able to address things like this. And so I don't know, sometimes it's prudent to wait another year. Sometimes the time to act is now. And I don't pretend to know what this is, but I think that it's, at this point, I think that we do need to consider, and I'm asking everybody in this room and everybody on this committee to help. And as we look at this, I want to get this right. I want to get it perfect. If we do something, I want it to be a model. Representative Gold, is the, I think I know the answer to this, but there's no other states that have really, we would be doing something that's a bit unprecedented if we created this type of commission. Is that right?
I believe so. I think New York has done something very different, but similar as far as an oversight committee. I don't know the results of that or when that happened, just in some research. It did come up, but in talking to a number of people, I believe that there's other states would love to see someone do this so that we have some, model language out there, paving the way, just being careful along the way that we do it, that it is the smart and appropriate way for us to handle it and still give prosecutors and solicitors the ability to do their job, but give us a way to handle ones who cannot. So maybe New York with an asterisk, I'm not sure that, but I don't know of anyone else.
And even though being a prosecutor is part of my career path, I can't say that I have taken the time or mental space to understand what goes on in other states and what other states have had, incidences of misconduct or series of incidences, et cetera. I have no idea, how that is with other states and what that looks like. But again, the series of events, I think, we're called to act as a body. We're called to act based on incidences that we observe and experience as a state, and that's part of our fluid, ongoing duty to the citizens of Georgia. And that, it is no secret that I have spent a lot of my time and energy and passion in this building advocating for prosecutors, because I have a great passion for what they do. And that's not a secret at all. But I also want to make sure that we have the ability to take action in rogue situations. And this is something that shouldn't be taken lightly, and it shouldn't be administered much. Hopefully, whether it be a task force or a commission or whatever it may be, that they wouldn't be called on to do very much. That would be my hope. But I think that after what we've observed the last couple of years, that we have to look at whether or not we're doing all that we can, on both sides of the coin of justice. And so, Representative McLaurin, are you number 4? Okay, I'm going to move to him.
Thanks, Mr. Chair. Good to see you, Representative Golett.
You too.
I have in the past, and I think members of my party have called for oversight of prosecutors. And so, to the chair's point, I think there's a real interest in getting this right, and asking all the right questions. Regarding what the bar has or hasn't done, one question I have just broadly to start with is sort of whether we walk into the opposite problem with a bill that's governed by political appointments rather than deferring to the technocrats who, lawyers who are trained in the profession. So if this bill puts the power to remove DAs and solicitors who are themselves elected officials, partisan elected officials, who are beholden not just to the practice of law, but to policy judgments by their constituencies. If we put the power to discipline or remove those people into a body that is composed pretty much entirely of political appointees, do we risk further politicizing the role of DA and solicitor in a way that's not contemplated currently under our Constitution?
Yeah, I think that's a good question, a fair question. The JQC is appointed by a bunch of political appointees. I think they handle themselves, well and appropriately. The Supreme Court of Georgia would actually ultimately have oversight. They're the ones who would remove the sitting DA. So, and also from an appellate standpoint. So if you can always appeal to the Supreme Court, if it was done politically and inappropriately. So I think there's a catch, a coverall for that, for us to handle that. But, there's always going to be a risk with political appointees in politics is bad, but I don't know of another way how you handle that. So how do you get technocrats to be a part of this, and how do you, I don't know of another commission that does that.
And Mr. Chair, if you want to set parameters on how many questions I get, there's a couple.
Ooh.
that you might want to. Well, there's a couple areas of inquiry that I'd like to just to give you a
Sure.
heads up on where I'm
Please.
headed. The first is sort of the substantive duties of the JQC in terms of specifically what the grounds for misconduct finding by the JQC are, because I think we all agree the JQC is the model for this, and so I think it's instructive to look at how the JQC handles the idea of misconduct. One thing I'd like to explore, if possible, is the difference between the grounds for discipline and Rule 6 of the JQC vis-a-vis the three main points that we're considering today regarding conduct by DAs and solicitors that needs to be, accounted for. And so one thing I wanted to ask is, the grounds for discipline in Rule 6 of the JQC's grounds for discipline rule, or sorry, I'm saying the same thing. Rule 6 grounds for discipline of the JQC is number one, willful misconduct in office, willful and persistent failure to perform the duties of office, habitual intemperance, conviction of a crime involving moral turpitude, conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. And when I look at the list of the three obligations of the district attorney or solicitor general here on lines 125 through 130, conduct that causes disrepute is a much broader category than conduct prejudicial to the administration of justice, which brings it into disrepute. And likewise, the JQC grounds for discipline identifies misconduct, persistent failure to perform, willful misconduct, willful and persistent failure. I mean, these are buzzwords in the law that raise the bar on the standard of conduct that we're talking about. But the corresponding provision here, subsections 1 or paragraphs 1 and 2 of subsection H here, uphold the laws of the state of Georgia and avoid making, and again, I would need a definition for extraneous judicial statements because I'm not quite sure what that means, regarding pending litigation. So I guess my overall question to you is, were these provisions modeled after the JQC? And if not, I would like to ask questions and explore as a committee what the policy justification is for changing the way that we identify what misconduct is, and explaining why we have such broad categories subject to the discretion of this new commission for district attorneys when we have slightly more surgical and focused grounds for misconduct for the JQC.
And I will say this, and Representative Gullett may or may not be able to analyze at the level that we as lawyers do the JQC conditions. Obviously, that's a lot of this is very industry specific to us, and we understand the discretion that a judge has and the parameters of that much more so than somebody that doesn't practice law. And so, if you have something to chime in, but I'm not holding you responsible for that, because I do think that could be outside of where you're comfortable. And we could certainly, there's somebody out there that can give us analysis on that, and I would love to hear that as well.
Yeah, I mean, this came from a non-lawyer. I did work with some district attorneys to come up with these three rules. They're not even rules. I don't want to even call it. They're kind of canons of guiding what the commission's rules would set. But these, with the ones I worked with, these are the three we kind of came up with, versus having tried to list everything specific. Didn't think we could cover that. So this is kind of the three canons that we thought were best. But it's Joseph's language, who's not a lawyer.
Yeah, I appreciate you saying that. I mean, the very last thing I'll say right now is, by way of example, willful and persistent failure to perform the duties of office is pretty strong. And you might imagine, I mean, maybe a judge sits on a motion for a year, right? And maybe an attorney doesn't like that and says, you failed to perform the duties of your office by not, addressing my motion for a year or two. But that wouldn't be grounds under the JQC rules for getting rid of that judge, because it says willful and persistent, right? My worry is that the way that these rules are written now for this new commission uphold the laws of the state of Georgia could be read in an absolute sense, such that if there was a case where a prosecutor exercised discretion not to bring a charge, that the political appointees would think, well, if we're upholding the laws, we have to charge every single possible set of facts, right? My concern is that the absolute nature of the way it's written now would put the DA or the solicitor under the spotlight in a way that judges even wouldn't under the JQC.
So I would say, but when you talk about these appointees, these are all appointees who are in the world of prosecutions. There's a district attorney, there's a solicitor. There are 3 people who've worked as a district attorney for 5 years. It's not citizenry who don't understand this as far as appointments. So I don't know if I believe what you say. I don't know if the end result would be what you're saying. But I'm however we get there, let's get there. But I think something needs to be done.
And so on that note, Representative McLaurin, and I'm asking for the help of folks that are in the room right now, uphold the laws of the state of Georgia. And my understanding is that, I don't know if it would be, I assume that's somewhere in your oath that you take, or, there's that's memorialized in somewhere, that upholding the laws of the state of Georgia. But then there's this concept of prosecutorial discretion, which I understand, and I know that all of you understand as well. Is there anything in the law, because it says uphold the laws, is there anything directly in law that cites the concept of prosecutorial discretion, meaning that you could be in compliance with number 1, as it's written in its very broad form right here, but still have the wiggle room to be able to exercise discretion? I mean, and I don't necessarily need an answer right now, but I think that's I understand what you're saying. And I think if we're going to really parse the words, I would like to get a better idea and sense of where the concept of prosecutorial discretion comes from. Does it come from case law? Is it something that is embedded in black and white letter somewhere? One of the things that I do want to say, going back to Representative McLaurin, where you started, one of the hard things about this, and frankly, a whole lot of other things that we do, is at the end of the day, we've got people that, whether it's a committee or a panel of the state bar in which you have relationships and you have biases and you have all those things, or whether it's a panel of your peers as prosecutors, no matter what we do, it gets us down to a panel or a group of people, and that whichever way we get there and however that group is defined, those same problems are persistent. And that's, unfortunately, one of the things. There's a lot of problems that we can solve. There's some problems that we can't solve. There's some problems that we can make worse by trying to solve them, right? And I'm not sure where this fits into that, but I think that argument can be made, in a similar nature to whether it be, like I said, a bar panel or a citizenry panel or whatever it may be, that there's going to be some intellectual flaw with how that works. And I think that's just one of the imperfect things about a lot of what we do here, and whether it's a political appointment or not. And, and I serve on several governing boards that the governor has appointed me to. And I will say that over the last couple of years, I've been pleasantly surprised to see how seriously a lot of the folks on these bodies take themselves, and they take very seriously when the governor or the speaker or whoever it may be, or the party appoints you to something. There's some kind of there's some kind of psychology with that what I have found is that people seem to take those things real seriously, and I think that's a positive thing. But at the end of the day, it's still a flawed system, because you're dealing with people that come from where everybody comes from, where they come from, and there are relationships, and there are things that in people's fiber that make them favor one thing or the next. But I'm going to move over to Chairman Setzler.
Thank you, Mr. Chairman. Representative Gillett, thanks for the bill. I think this is a very appropriate conversation. And I think as we think about this, what Representative McLaurin said to me reminded me of something I wanted to bring to you. I think it's central to what we're doing as a committee, is digging into the power dynamics inside this organization. I mean, how does I use the term power dynamics, but it's really when we study civics as middle schoolers and high schoolers, 50% plus one of the House of Representatives and 50% plus one of the Senate, and goes to the governor. That's the structure. But those of us who've been at the Capitol for a while, the real story about this Capitol or the U.S. Capitol are the power dynamics. How how is the system set up? Where is there a, who's going to, I forgive the term, who's going to prosecute the case against the prosecutor in front of this panel? And what's the, and again, I don't have vast knowledge of the details of how the JQC works, but I think those dynamics are very important. I think that the appointment powers are important. But I think as we go through this, we really have to understand, how do you create pressure in the system so that, I mean, if there's a contention of prosecutorial misconduct, who's bringing that case? Who's building the case? Who's bringing the case? Is it sort of the staff of the appointed commission, or is there somebody? Are we creating an adversarial system, the positive adversarial system we have in our court system, so that there really is a real good shakeout of the related facts? And secondly, what's our strike zone? What are we clear about what conduct we want to say a prosecutor might be removed for? What conduct a prosecutor might be censured for? What's the array of options, and what are the standards that we establish to try to make that happen? I think we got to be clear about, and that's where my words morph into a question to you. Are you clear about what exactly you're trying to accomplish in terms of remedies and behaviors? Do you have a set of, if this kind of thing happened, we ought to do thing A. If that kind of thing happened, we ought to do thing B. And just as you work this out in detail, have you thought through those dynamics?
No, and I think intentionally I have not, because one, I don't want to go into it, my biases of what I think should happen. I'm not a district attorney. I don't know the things that district attorneys need to go through. What I do know is that there are a handful of things that have happened lately with district attorneys, and I know how difficult it is to do anything about it. One, we were very separated from that opportunity. There's no oversight for district attorney today other than the bar, unless they have a felony. I haven't seen the bar do anything today. So really it's outside of, if you do A, then B happens to you, or if you do B, I believe that should be up to, and I want the district attorneys and solicitors to be part of that conversation.
Which is why and not to interrupt you, but the reason why you want them to retain rulemaking authority is so that they can achieve that.
That's right. And they're the ones in that business. I think they best handle that. Knowing it, I believe that district attorneys believe something is going to happen. I believe that a number of district attorneys want something like this because they're getting a bad rep for other bad district attorneys around or solicitors around. But no, I haven't in my mind said, if you do this, then you're out of this should be your punishment. I thought about it personally, but I haven't used that in any kind of directive of creating the legislation.
And I'm not suggesting you hard code that in statute. I'm simply saying, when you create the dynamics and that you create the tension by the way you set this up, those will emerge, and you could have district attorneys, you could have experts who live in their world, who are creating a really good kind of a contour there, because you create the structure to make that work. We're not going to solve that in the four corners of this bill. I just want you to think about those dynamics. I also, question, Mr. Chairman, is, are you wanting this entity to look at a decision by a DA and say, bad decision, you shouldn't have shot the death penalty for this, or you shouldn't have brought or you shouldn't have done a plea in this case, or you shouldn't have brought these charges to get the person to plea because these charges weren't credible, and you're being a bully there. Are you trying to address those things?
No.
So can you tell us what exactly, and I'm not being adversarial, I'm just asking a question.
No, that's a good question.
What exactly are you trying to address?
I think there are a number of issues around the state that have happened, and I don't want to, we can play it out here or we not, but this is not to second guess a prosecutor for a particular decision that they made. This is really to give them some guidance on how they should act from an overall standpoint. One, we have, I think there's a district attorney in Macon who spent civil asset forfeiture money incorrectly. I think everyone, who looks at that would say that's an incorrect, use of the money. We have district attorneys with sexual harassment who begin getting investigated, people lose faith in this in the system, and that's really what this is to address. Is for the people who district attorneys or solicitors who are acting incorrectly, poorly, and they're representing, people lose sight. We continue to talk about justice and getting justice for people, but if people don't believe in the district attorney, there's decisions that have eroded that trust, and they're quantifiable, not a feeling, but hey, this person has violated some sort of law. This person has said, I'm not going to prosecute any, we would all agree if a prosecutor said, we're not going to prosecute any white males, that's a problem. We don't want prosecutors to think in a holistic stance. We want them to look at each single individual case on its merits and decide. And so that's really the bigger picture of what I'm trying to do here. It's not, hey, you didn't prosecute this one case, and I believe you should have, and here's a case that should be thrown out. I would think, immediately if there's a prosecutor who's having an affair, doing something here and there, causing causing an uprising inside the office, that's a problem. Paul Howard was a problem in my mind for Fulton County, and I believe that's why Democrats, the other side dropped the bill last year to handle that. I think we all can agree that was, that's a problem. We have them all across the state, and so this is really to address and have an opportunity to address those. Whereas we don't have that today. There's no oversight. Sheriffs have a means to be removed if they're acting properly. Everyone does. Prosecutors really don't, in a realistic sense.
And I think what I'm hearing, and again, I don't know how to perfect the words on the paper here. There are certain things that essentially kind of shock the conscience when and there are certain positions that you take in life. And if you take on that position and you're given that opportunity, you're held to a higher standard. And that's part of our society and culture. And frankly, that's a good thing, should be. And there are certain things that can happen that's hard to put into a jar of a category, but it shocks the conscience. You know it when you see it. And the way I think that I'm understanding what you're trying to figure out how to accomplish here is a way of those situations that are frankly impossible to categorically say, these are the things that this group would have jurisdiction over, and these are the things they wouldn't. I don't think it's that simple, which is what makes this so challenging, right? But I've got a lit up board here. I'm going to go to Representative Lopez, who computer audio. So Representative Lopez, are you able to, can you hear us? Can we hear you?
Yes, thank you, Chairman. Can you hear me?
We can hear you.
Can you hear me?
Yes, we can hear you.
Okay, thank you, Chairman, and thank you, Representative Gollett, for your bill. I had to log in a little late, so I don't know if this was discussed earlier. I agree with Chairman Setzler that this is the right time to have this conversation. So I appreciate you bringing that with this bill in front of us. My question was regarding the composition of the commission and the conversations or your thoughts on that. I saw that all members on the investigative panel are on the prosecutorial side, either a district attorney or solicitor general. Any thoughts on that? And I tend to agree that any member of such commission should have a background in criminal law and practice in criminal law. I just wanted to know why not having any member on the defensive or being on the other side and not just the prosecutorial side. That was my question.
Sure.
And I think, well, in of the 5 investigative panel members, one is a practicing attorney that's no longer a prosecutor, or no.
They're all related. So,
Yeah. And then the senior judge, in the hearing panel slate, one is a citizen member, and one is a senior judge. So those are 2 out of the 3 in the citizen, I'm sorry, 2 out of 3 in the hearing panel would be non-prosecutors.
Right. And I thought it was important. I don't know that criminal defense people who work in that world know exactly what prosecutors do. And I think from an oversight perspective, I thought it was best to actually have people who have experience in the office to understand the dynamics and how things work in that world. That's kind of why we decided, or I guess really I decided that it was best. In talking to other prosecutors, they thought that was important to have prosecutors judging their actions instead of non-prosecutors for the most part. From an investigative standpoint, they understand what you have to do in the office. They understand the stresses and everything that goes along with that, so they can make a better decision on things. But that's why we came up with that.
Okay, I'm going to move back down to Representative Bodie. 15, right?
Yes, thank you so much, Mr. Chair. And I want to clarify my statement earlier. As far as the task force that's working on the bar rule 3.8, they have voted to have reprimand upgraded to disbarment. And so that's going to be presented in March of this year to the disciplinary committee, and it should be passed. So the DAs are actively working on upgrading that. Now, and again, I appreciate the sensitivity of this because we have dealt with this, and Representative Gully, I know you're dealing with it as well, and we'll just kind of leave that on the table on both sides. However, I think in having my conversation with DAs on both sides of the aisle, the concern that we have is that judges are nonpartisan. So when you have the JQC, you're dealing with a bipartisan elected official. But in this case, our DAs and our Solicitor Generals are partisan. And so when you have the investigative committee and you have the hearing panel being appointed by, members of the other party, in this case, Republican Party, you have Democratic DAs and solicitors who might be the subject matter of an investigation, then you're going to have political tensions. And I just want to, I wanted to see if that's something you thought about as well, and is how we address that concern, because politics will play into this. And my second and last question would be, if, going back to your statement about indicting individuals, if you had a situation where a DA decided or a solicitor decided that I'm not going to prosecute any of the possession of marijuana less than ounce cases, and I'm going to send them straight to pretrial diversion, your panel could actually come in and say, no, you have to prosecute because that's the law. But we're not taking into consideration that the citizens in the constituency elected this DA or the solicitor to make those type of decisions. So
Yeah, but the legislative branch, this is where the legislative branch gets to decide what the law is, though, Representative Bodie, and that is our job. And while there is this concept of a case-by-case prosecutorial discretion and sending marijuana cases to diversion as opposed to flat out dismissing and making clear that you have no intent to prosecute in any form or fashion a marijuana case, those are two very different things. And our laws allow diversion programs, and that is allowable by our law. But to make a decision that you're categorically not going to prosecute a type of crime is usurping what we do in the General Assembly, and that is not constitutional.
Mr. Chair, respectfully, it's that prosecutor's decision on how they want to pursue or deal with their caseload. And I understand your position.
It's an unconstitutional position for a prosecutor to categorically say, I'm not going to enforce 16-5-1 or whatever law may
Well,
be.
Mr. Chair, not enforce, but decide to send the cases to pretrial.
We're talking about two different things,
Yeah.
but there have been instances in the state that I know you're aware of, that we're all aware of, where prosecutors have uniformly said not prosecuting in any form or fashion these types of crimes. And I do believe that that is unconstitutional.
Mr. Chair, we respectfully disagree with you on that one.
Representative Sains.
Thank you, Mr. Chairman. And just so I appropriately ostracize myself from the beginning, you kept saying you're not an attorney, and I wasn't sure if you meant that as a disclaimer or a credential, because I take it as the latter.
Both.
But with, looking at to what the chairman was alluding to, I look back and parallel this to two things. As a deputy sheriff, when I was, if I were to see a crime being committed and decide I was okay with that crime and not enforce that, that would be a breach of an oath of office. The sheriff, which I would serve under, would be in violation of an oath of office, and there is a way to remediate that in Georgia law at this time. And this is trying to parallel the another chief law enforcement officer, the elected district attorney, to the likewise. So that I don't understand the notion that because it's an elected official, there shouldn't be basic minimum accountability standards there. Could you clarify that? Because I think it's easy to get lost in a lot of the testimony here. Is the intent of this law to ensure a basic minimum standard of what the district attorney is supposed to provide its citizens in terms of enforcing the crimes that come in front of them to prosecute?
Partially, I don't think it's just about enforcing the crime, enforcing the crimes that they're prosecuting. It's also about the things that they do personally in their life, their actions as well. So partially, but it's more than that.
Actions, and to further clarify, actions that
As a
would
prosecutor.
impact the credibility of their prosecutor.
That's correct.
Their office. Thank you.
And also controlling their staff too. So if an ADA is acting inappropriately, ultimately the accountability, that's why we only did elected. The accountability stops with the elected. They need to correct that action. So it might not be them, but as soon as they find out, they need to handle the situation.
Thank you.
All right, I'm going to briefly let Representative McLaurin. You still have a question? Can you be brief? Because I want to move on to some other witnesses.
Okay, sure. I mean, I guess, well, the first thing I'll note is that to Representative Saines's comment, I'm actually not an attorney under the definition provided in this bill, and that makes me feel small, but it also makes me feel young, so I'm okay with it. The question I have for you is, I try not to turn into a national partisan cable news rage monster very often, but we've had a lot of conversations in the last few years about how elections are the proper remedy if a duly elected official is not performing their basic duties, and that we shouldn't have, interventions by other officials, even in a separation of powers context, like impeachment, for example, to interfere with the will of the voters, unless there's some sort of completely insane, and based on recent impeachment proceedings, I don't know how insane that standard actually is, standard for conduct that would require removal.
And
so
keep going.
I guess my question is, are we and to the chairman's comments, are we really trying to establish a board whose purpose is to remove prosecutors that make categorical prosecution decisions in their discretion that their voters are supportive of? I mean, because if that's what's happening, there are going to be a lot of people strongly opposed to this bill. And I just hope that that's not what's happening.
Well, I don't think that's what's happening. I think what we're talking about is some of the things that we've seen across the state, some of the decisions. And I think that when the issue came up about marijuana and sending them to diversions or just not prosecuting them. And I do believe, I'm just saying, me sitting here, I believe that that's not constitutional to decide to usurp the legislative body's standing on what is against law and what's not against law. I believe that's unconstitutional. But to answer your question, if you go to line 14, it references Article 4, Section 8, Paragraph 2 of the Constitution of Georgia. The actual Georgia Constitution does give the General Assembly the right to remove, force the early retirement of, discipline elected district attorneys or solicitor general. So it's embedded in our Constitution right now. And so this bill is a product of what the Constitution allows us in this. But as far as my comments on which was in response to what Representative Bodie was saying, I do not believe that is a constitutional decision. I don't believe that an elected official in a judicial circuit has the constitutional right to do that. Whether or not that's something that's contemplated by numbers 1, 2, or 3, I have no idea if that's contemplated there. But as a sidebar, I don't think it's constitutional. So,
Descending from my rage monster fit that I just went into.
me too.
Thank you, Mr. Chair. I would like to propose a committee or ask the committee if it would be willing to start with the JQC grounds for discipline as a model. I know what you're saying philosophically in the abstract, very difficult to come up with buckets of misconduct, but we have a starting point. The JQC delineates some categories, and I think it would be helpful to start there and then try to think about how the DA role or solicitor role is different that would require different language.
Okay. And then I'm going to go back to Representative or Chairman Setzler, and then we're going to move on to some other witnesses.
Very quick. I don't know that I don't know the details of the JQC criteria, but I do think it would be helpful to define a sphere of the kinds of issues that the commission would deal with. I think I think it being as broad as it wanted to be, there could be mission creep over time. It could start to delve into spend more time on certain things than others. I do think we need a strike zone, as it were. I'm giving you no specific direction, but I do think a list of criteria, whether it's personal behavior, personal professional behavior, and that's just one I think we would all agree should be there, and some enumerated list. I think that'd be helpful. That's all I wanted to say, Mr. Chairman. So.
All right, Representative Gullett, I'm going to move on. And so what I'd like to first do is have Brad Rigby. And DA Rigby, tell everybody where your circuit is and how long you've been there. Thank you. You've been a frequent flyer in our committee here, and we appreciate having you. You can take your mask off if you want while you testify.
Appreciate it. Thank you, Mr. Chairman and members of the committee. Appreciate the opportunity to speak with you today. I am from the Cordele Judicial Circuit. I have 4 counties. I have Crisp County, Dooley County, Ben Hill, and Wilcox County. They're my 4 counties that I work, a rural circuit in South Georgia down I-75, about 2 hours from here. Several of the issues addressed by Representative Brody and others here today have kind of play into what I want to talk about initially. To give you an update, Sherry Boston, there are a group of district attorneys and solicitors as we saw issues arising in our body that we wanted to address. And we as district attorneys and solicitors came together to strengthen Rule 3.8. We've already done that as a committee. We have recommended language to the state bar, as Representative Brody has already mentioned. That actually, just to give you an update on that, it is in the Disciplinary Rules Committee meeting right now. Sherry Boston is a member of the Board of Governors. She is the district attorney in the DeKalb circuit and has been working diligently in that regard with the state bar. It is set to be at the Disciplinary Committee Rules meeting on February the 24th and to be voted on. It's on track to be voted on by the Board of Governors on March the 20th at their meeting. Currently, as mentioned earlier, the discipline is a public reprimand. This is strengthening the rule to allow disbarment for those attorneys that violate Rule 3.8. This would be handled under the state bar, who is capable already of investigating these complaints that are filed, as well as making those decisions in that regard. Just for your information, and it is public information, I'm not revealing anything that is confidential, but there are 4 electeds right now that have complaints filed against them with the state bar. That said, just letting you know those things is what we have done as a body to address these issues that this committee is concerned with today. The next issue that I would like to just speak about is that, as stated earlier, there are no other oversight committees like this in the United States. We talked about briefly an asterisk by New York, but to our knowledge, there are none like this. And so whatever we do here that y'all decide to do, it will be a model for any other state around the nation to do that. And as you addressed earlier, we need to be surgical about this and not so broad as we have already. And I appreciate your comments on that, because if we go way overbroad, then we have someone questioning every decision that we make and every discretion that we make, not only victims, not only defense attorneys questioning decisions that we make, not only defendants questioning decisions we make, but the victims a lot of times are not happy because we didn't get what they wanted in the case. And then we're going to have that impact as well for us to deal with. And so we need to be very careful and surgical about that. Whether we make it too narrow or too overbroad is a concern that we have as from Prosecuting Attorneys Council, the DA's Association, as for the solicitors as well. Something else I'd like to address is we have prosecutorial duties that, and over the past couple of years, the Attorney General's office has also assumed prosecutorial duties around the state. And are they going to be included in this bill as well? That's another question I have. There are separate prosecutors for juvenile courts around this state, then probate courts around this state, and municipal courts around this state. Are they going to be subject to this same bill, this same oversight, as this bill only says for elected solicitor generals and district attorneys? Are these other prosecutors going to be included in this bill as well? When Representative Gullett mentioned earlier about an assistant DA, are now we're going to hold responsible the DAs for assistant DAs conduct or that we should have known about or didn't know about, and we're going to have to address those issues. Or our staff members, our victim advocates, or whether it's just an administrative assistant that works in our office, are we now going to be held responsible for their conduct? And so all of those issues are things that are concerning to us as district attorneys. Now, not that we're opposed to this, we're here ready. We've been actively dealing with it ourselves. We want to make this, if this is something that you feel we need to do, then we're ready to be here and work with you in that regard. The other issue that I saw in this was the recusal issue in this regard. What happens when a defense attorney goes out and hires a commission member to represent him, and now the entire DA's office is now precluded from prosecuting that case, and it lends to DA shopping for that particular defense attorney or defendant that has now hired the DA that he wants to hire. Those things are a little bit concerning for us. We have 49 circuits of district attorneys around this state that all work differently. We're all different circuits. We all have different constituencies. We all have different ways in which we address crime and use our discretion in prosecuting cases, whether it's putting things in pretrial diversion or whether it's taking something and putting them in community service or it is prison time, depending upon the discretion of the case and how our constituency views crime and wants to handle and deal with crime. So those things are something that kind of broad. Of course, our solicitors, we don't have a solicitor in every county, but 159 different solicitors. If you take all the counties, not quite that many, but we have many of those that we are concerned with as well when we deal with all this. Another representative over there to the far left, and I apologize, I forgot his name, but nevertheless, he brought up a great point. The duties of the prosecutor are already outlined in the official code of Georgia. They are in OCGA 1518-6, which gives us the duties of the prosecutor. And one of the duties of the prosecutor is that we are to prosecute all indictable offenses. Now, we have discretion in that to look at those charges to determine if probable cause exists. And one of those ethics complaints, if we are indicting cases that there is no probable cause, then that's an ethics violation. And then we are held to, that's under 3.8. That's already set forth in the ethics rules. Part of that is we also take an oath of office. In 1582, OCGA 1518-2, we swear to faithfully and impartially, without fear, favor, affection, discharge my duties as a district attorney and take my only lawful compensation. So I am under an oath of office to enforce the laws of the state. That's what I'm under an oath of office to do. And if I don't, there's what's called a violation of oath of office, which is a felony offense for the state of Georgia. It is in 1610-1. And so there is already a felony offense for someone who does not uphold the laws of the state of Georgia and follow their oath. That said, we are under the bar rules with 3.8. We have, as a body, come together to strengthen those rules, to update the discipline to disbarment. Those things are there. We have some other concerns about the, as you pointed out earlier, in fact, number H2 in the bill itself, it talks about that we are to avoid making extraneous judicial statements regarding pending litigation matters within our jurisdiction. Well, that is actually in conflict with Rule 3.8. Rule 3.8 allows us to make statements. This one would say it's an ethics violation that I can be, brought up on charges for, when the ethics rule, as by the state bar, does allow for statements that would, and I have it here what it says that except for statements that are necessary to inform the public and the extent of the prosecutor's action that serve a legitimate law enforcement purpose. And so if I have one murder defendant that's been caught, but I have another one on the loose, certainly I can go out and make a statement to the public that we still have one charge, but we have one person that we are still looking for. However, what's in this bill says that I'm making an ethics violation, or now I'm going to have a complaint filed against me. And so again, we need to be much more surgical about those things and make what's here compliant with what is in the rules themselves. I have a copy of how we have strengthened Rule 8. I didn't make a copy for everybody. I apologize for that. I just didn't have the ability to do that right now, but I do have how we've strengthened Rule 3.8 for the committee. But I just wanted to address some of those concerns. Some of my fellow prosecutors are here and may address some other concerns, but that's kind of some of the issues that we saw and that we've kind of already addressed here today. But I'm certainly willing to answer any questions that you may have.
And thank you. I couldn't write fast enough.
Sorry, I talk very fast. Yes.
I tried to take copious notes here, but that is exactly what we needed to hear, is everything that you just talked through right there. And there's a lot to unpack there. And looking at this, and I think the question for this committee on this issue is, if we're going to move forward on this, we need to make sure that this conforms with just about everything that you just said. And I think that again, I couldn't write fast enough. So somebody else here could take better notes than me, or perhaps we'll all be talking after this, but I very much appreciate your input on that. Does anybody else have any questions or comments for DA Rigby? Chairman Setzler.
Quick question. And again, I know there's not a complete alignment here. Are you familiar at all? And this is not a leading question. This is actual.
Sure.
Question. So I know you understand leading questions, perhaps. The standards of judicial conduct that lays out, there's sort of sections and there's subsections to it. Is that kind of framework? Is that what you're talking about in terms of drawing this down and having some whether it's in statute or otherwise?
So we have the judicial conduct is going to be different than the bar rules. And so we're going to have just a difference in that. But the prosecutor rules are already delineated in Rule 3.8 in the ethics section for our ethical rules, going to be different than judicial conduct rules. And then we have, of course, the duties that are set forth by statute that the legislature has enacted for us to follow. I'm not sure if I've answered your question, but I mean, ours are going to be different than the judicial conduct. But they do kind of set out, our duties, what we're to perform, and then how, what is a violation of our duties and those respects in Rule 3.8.
Okay, so as I'm looking through, 15, 18, 6, obviously this is way more general. How would you? I don't have 3.8 in front of me. Just describe for me, as a member of this committee who's not familiar with that, what kind of specificity is in the Rule 3.8 that you're talking about, that you're subject to?
So 3.8 just says that we shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So that gives us discretion to review the cases on a case-by-case basis. And if we don't believe that the charge is supported, that law enforcement has taken, then we're not allowed to prosecute. That would be an ethics violation. We're to refrain from making any effort to prevent the accused from exercising his rights to obtain an attorney. So we can't do any action that would prohibit him from doing that. Would make an ethics violation. We're to make a timely disclosure to the defense of all evidence or information known to us that negates the guilt of the accused or that mitigates the offense. We are to exercise reasonable care to prevent persons who are under the direct supervision of the prosecutor from making extrajudicial statements that the prosecutor would be prohibited from making under this rule. We are not to subpoena a lawyer in grand jury or other criminal proceedings to present evidence about a past or present client unless we believe the information sought is not protected from disclosure by any applicable privilege. The evidence sought is essential to the successful completion of ongoing investigation or prosecution, and that there is no other feasible alternative to obtain the information. And then G is the one we talked about earlier about the other extrajudicial statements.
So do you think that list is, in your opinion, is that list complete, or does that need to be fleshed out in more detail? Because I mean, the underlying issue that the Representative Gullett's getting at is there ought to be a process and a system to sort of adjudicate this, but that he believes it needs to be fleshed out in more detail than we have now. Would you agree we need to flesh that out in more detail?
I don't know that I agree or disagree. I'm not sure if we're just going to put those Rule 3.8 into the bill that I'm not sure the purpose of that, because the state bar is already there. And I guess we're just going to have another committee doing what the state bar does and having the same review. But, that's certainly not my decision to make.
I'm sorry, go ahead, finish.
I was. Sure.
Do you have anything else? Does the bar have any, obviously understanding the context of the JQC, does the bar have any jurisdiction over judicial matters with judges, or is it all relegated to the JQC?
I honestly can't answer that question. I think that certainly I know that bar complaints are filed on judges with the state bar. Now, whether they just refer them to JQC, somebody else with more knowledge about that procedure, I don't know.
That would be talking about
But I know
the
that there
dual
are-
jurisdiction thing. And I don't even know the history. I mean, I assume there was a time where we didn't have a JQC, and probably the bar did resolve or govern the ethics of judges before the creation of the JQC. And I don't know the history there. It would be interesting in light of this to have some context there. Does anybody else have any questions for Mr. Rigby? Representative McLaurin.
Mr. Chair, this is actually just a response to what you were just
Mhm.
talking about. I think a lot of times with courts, higher levels of courts administer discipline, right? So appellate courts administer discipline for trial courts, that sort of thing. So that's a function that's not as available, I guess, in the prosecutorial context. But that's all I had.
Sure, yeah. Anybody else for Mr. Rigby? Thank you. That was incredibly helpful, and I think gives us a lot to think about. Next, I'm going to call Barry Morgan, my Solicitor General in Cobb County and longtime friend. So thank you, Barry.
And one of your constituents
That's
as
right.
well. I speak today. I'm Barry Morgan, Solicitor General in Cobb County. I also serve on the Legislative Committee for the Georgia Association of Solicitors General. I'm standing here today in that role. Let me say that we are having a discussion tomorrow about this subject matter. So I'm not in a position to really comment other than to say that we would like to be a presence at the table and have input into whatever your decision is. But what I did want to talk about is a little bit about what Chairman Reeves brought up about the discretion. Where is that articulated? It's in 3.8. In the comment section, it says, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. The responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided upon the basis of sufficient evidence. It goes on at the end and says, applicable law may require other measures by the prosecutor, and knowing disregard of these obligations or a systemic abuse of prosecutorial discretion could constitute a violation of Rule 8.4 misconduct, which is subject to disbarment. Let me give you an example based on your conversation today about a concern I have. So I agree with you, Chairman Reeves, that, I don't make the decision about what's legal and what's not illegal. You do. And as it stands, and what I tell everyone in the state of Georgia, marijuana is illegal in this state. You also give me authority to set up a diversion program. And I've done that in our marijuana cases, as Representative Bodie said. But let me also put you in the situation where the state of Georgia, I attribute no fault and no evil means to this, but the state of Georgia several years ago made it a legal impossibility for me to prosecute and take someone to trial for a misdemeanor marijuana case, because we have defined marijuana and hemp and did not give us the resources to prove that in court. We took away from the local jurisdiction the certification to test marijuana because it did not quantify the amount of THC in there. And the GBI says we are not going to test misdemeanor marijuana amounts of marijuana so that you can utilize that in court. So then I get the dilemma of what am I going to do with that? Because I have the authority, I have the responsibility to prosecute those cases, but I also have this Minister of Justice under 3.8 to not bring forth a case that I don't have sufficient evidence. That's what the the comment says. So that's the dilemma I'm placed in, and that's, again, why we want to be at the table to be able to help fashion whatever is fashioned here.
Great, thank you. And as I said at the beginning, sometimes we can solve problems, sometimes they're impossible to solve, and sometimes we make them worse by what we do here. So does anybody have any questions or comments for Solicitor General Morgan? Okay, thank you, Barry. And Solicitor Gamage. Very glad to have you here, and always welcome you to this committee. Mr. Gamage is the solicitor in Fulton County, and he is a great man and a great prosecutor, and I'm proud to call him a friend. So,
thank you, Mr. Chairman and members of the committee. I serve as the Fulton County Solicitor, and in that capacity, I am going into now my second term. And I am appreciative, Mr. Chairman, of the manner in which you've conducted this hearing and the manner in which the committee has given thoughtful consideration to these very important issues presented. I did a quick mathematical calculation here. You know, some would say the lawyers are not the best mathematicians, but there are 49 elected district attorneys in the great state of Georgia. There are 66 elected solicitor generals. My colleague, Mr. Rigby, pointed out that there are 4 complaints pending before the state bar. I don't point that out at all, learned gentlemen, to undermine the fact that we've seen problems. That's true. But and I speak for myself today, although I'm a member of the State Bar Board of Governors, and DA Boston is chairing the committee to strengthen and improve State Bar Rule 3.8. My colleague in the neighboring county, Solicitor General Coleman Stribling, also a member of the Board of Governors, we are in tune with this issue. I'll underscore again, I'm from Fulton County. I've seen closely, without going into details, some of these issues come to bear. But gentlemen, we are accountable to our citizens. Please let me be an advocate for my citizens. I respect this bill, I do, and understand it. But the notion of limiting my ability in my home jurisdiction to understand the sensibilities and the needs, not only of the citizens of our great state, but those, Mr. Chairman, most important to my community that sent me to perform tasks that are both within the constraints of the law, but that fulfill the needs of my community. I'd like to share just one example. When I was elected back in 2016 and took office in 17, Governor Deal and members of this grand body put forth great legislation that more strongly empowered us to give folks second chances. But there were people in our state who didn't agree with the way I chose in my county to deliver those second chances through faith leaders, through the business community. And I heard these voices. I did not have to come before a panel though and have well-meaning, right-minded folks take a second look at the decisions I was making within my county. I highlight that particular initiative, gentlemen, members of the committee, and Mr. Chair, because soon thereafter, I was honored to stand with Governor Kemp. And when he signed Senate Bill 288, the folks in that room, Representative Houston Gaines, Senator Tanya Anderson, whispered in that room that, Gamage, if you and other folks had not led in this initiative, the governor wouldn't be signing this bill that you all both supported bipartisan in a bipartisan way that will provide those second chances. The folks in Habersham County that may not be the best approach for them. The point I make, and I apologize for being long-winded in doing so, is that when our sovereignty is limited by constraints other than the state bar rules that we follow, there is concern about political pressure. And I speak personally saying I trust the members of this body I would ask you to trust the great majority of us prosecutors, members of the state bar, to figure this out. Please give us some time. My ask is to let us continue to work through the state bar. If you're not satisfied with what Chair Sherry Boston, other members of the committee through the Board of Governors present, please then take another look at it. The bill is right-minded. I commend you all for it, for bringing it up. I know that the Democrats, the party in which I hail from, had discussed a similar bill, but even the notion of, it says that we've got to uphold the laws of the state of Georgia, position or point 126, number 1. Every prosecutor has to do that already. And if I choose, gentlemen, or a neighboring prosecutor to decide that my resources, the limited resources that anybody who's ever prosecuted knows are present, I've got to use my limited resources, Mr. Chairman, to prosecute serious domestic abusers. I have to use those limited resources to decrease gun violence in my community because people are up in arms, and rightly so, about violence. I have to use and streamline those resources to prosecute multi-offender recidivists. And so if I choose, trust us, to choose that we've got to allocate these limited resources in a way that's ethical, that's fair, that's just, that's appropriate, it might very well mean that with these limited resources, marijuana becomes less of a priority. I've never taken a stand that I will not prosecute any particular case. I know that others have for various reasons. But my point is, as I wrap up, I handle about 100,000 different criminal and traffic matters and represent 1.64 million citizens in Fulton County. We heard from Mr. Rigby from Cordele. We heard from Mr. Morgan from Cobb. This is a bipartisan effort, in my view, from prosecutors who say, too, we want to get this right. We want to get this right. Please give us more time to work among ourselves and to come to you with something that may be satisfactory to all.
And thank you. And I just want to highlight you've raised some excellent points there. There isn't another prosecutor, I imagine, in the whole state that has the volume of caseload that you have. It would be my guess. And I know how busy your office is. I've had cases with your office, and I know that those challenges and this here. It's awesome when you just have one bill on a calendar, right, or on a hearing, because you can actually talk about it and get into it and not feel the pressure of I wish we had more time. Although I don't want us to be full time, that'd be a disaster. But this is exactly what I was hoping when I came in here today. This is exactly the kind of dialogue that I was hoping that we were going to have, and the kind of things that we were going to discuss and issues we were going to raise. I don't think that anybody, I think to boil it down, I think that the consideration right now is, there's an effort with the representatives bill moving forward legislatively on something. There's simultaneously an effort going on to empower the state bar to potentially achieve some of the same goals that this does, and which would come first, the chicken or the egg, right? And I think that needs to be part of our consideration. But I think that what we've realized is that this is a hard it's a hard issue to solve, and I say this to say that I don't think that what anybody's intention is to encroach upon you have legal discretion, and you use that, and you have resources, and Mr. Morgan raised a great issue with a conflict in laws that have been created that potentially preempt certain prosecutions. I don't think that anybody here is trying to get a gotcha on anything. I think that, in fact, I know that where this is coming from is that we've had, a series of high profile incidents that are shameful, that, you know, it's everything I've done in my career. The thing I'm the most proud of is the 5 years I was in the DA's office in Cobb County. There ain't anything that I'm more proud of than that. And I take a tremendous amount of pride in that, as every one of you in this room do. And, you know, the point here is not to play gotcha, not to encroach upon your ability to utilize your resources, read your community. We want you to be able to do within the requirements of the law what you have to do to get done what you got to get done. But the design of this is us responding, and I think that we are appropriate. It is well within our jurisdiction as a General Assembly of Georgia to respond to what is frankly, you know, been, you know, granted, you are absolutely right. These have been outliers, but they've been notorious. You know, they've been very, they've hit hard on the Richter scale, right? And it's brought a lot of publicity to Georgia, and it's made a lot of great people that get up every day and do their job with the greatest intentions, you know, look bad. And that's something that I do believe that this body has a duty to address. And so, you know, the question is what is the best way to do that? And I think that that's what, when we're finished with this hearing here today, which is about to happen, and I do need to let Ms. Travis with Gactyl speak, but you know, that's what we've got to look at. And I'm very, very appreciative of what you offered today. And I think that that's very good perspective for us to understand. So thank you. Can we get Ms. Travis, you should be able to get on with the computer audio.
Can you hear me okay?
We can, yes.
Yes, good afternoon, gentlemen. Thank you for having me via Zoom. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. As you can imagine, we have an interest in making sure our prosecutors are held accountable, just like every other lawyer in the state. I'm not going to repeat what's been said, but I do think that Mr. Rigby had seen my notes before he testified, because I swear to you, we were going to say, I had so much of the same information. In addition to him pointing to the 1586 on the duties of that they need to uphold, I'll point you to 151824, which allows for impeachment if they don't uphold those duties, and 15826, which also talks about curbing the practice of the prosecuting attorney and how they could be could come into trouble for not following those rules. Seriously, Rule 3.8, I'm so glad that Mr. Rigby had a chance to read that to you. I know what he didn't read to you was all of the additional changes that they are looking to make. And, you know, it's probably, we don't need to go into that, but there are quite a few things that are under consideration that I think will get to the point of a better place for prosecutors to be held accountable. Specifically looking at the bill, it's been mentioned that some of this vague language causes disrepute. What does that mean? If you guys are talking about sexual harassment, maybe that's something that should be said. As you know, there's not been, you know, the General Assembly has just been dealing with sexual harassment in the last few years, where that's come truthfully into, you know, things that you have to sign and committees or things that you have to watch with respect to learning what sexual harassment is and a reporting authority. I don't think there is anything in the state bar rules about sexual harassment. So that's something else that's out there for lawyers to have to deal with in a larger manner. So the vague language, the other thing that I wanted to point out to you is this isn't a lot of money from what I heard, like $900,000 to deal with every for a few cases. So that just strikes me as odd. The composition of as you pointed out, Chairman Reeves, the hearing panel itself has a little bit of diversity in terms of the players, but the panel of investigators are all former prosecutors, and it might be good to have perhaps an employment lawyer involved in the situation if you're dealing with employment matters. And also I can't remember which member pointed out the fact that now in the current composition of the political leadership, it would create a one-sided appointment process with all Republicans. I'll also just point out to you that in my eagle eyes, you've got some typos in this bill. It looks like it was pulled from the JQC, and there are some judges where there should be district attorneys and solicitor generals. I really appreciate the time to talk to you today. Happy to answer any questions, and I hope that we'll give this some more study.
Does anybody on the committee have any questions for Ms. Travis? Okay, see, now, thank you, Ms. Travis. So, before I adjourn, I will get with the author of this bill, and we will, we'll talk, and I imagine that this will be a collaborative effort, and we will see where it goes from there. And I think that what we would like, I can't speak for the author of the bill, but I can speak for myself. What I would like is more information about the expansion of Rule 3.8 and a better understanding of what the pathway of disbarment really looks like under that, under what is being proposed there. You know, there's more than one way to skin a cat, right? And I think that for this body, we need for us to decide whether or not, and this committee to decide whether or not this is something that the General Assembly needs to move forward on, or to defer to the bar. The details are extremely important in that. And I understand that there's some things, I understand the momentum that's going and the vote that's coming. And my guess is that we would probably continue to move forward with the bill. And if this is passed by the Board of Governors, and that would be a consideration that can take place after March 20th, would be what my thoughts are. But I want to continue to work with y'all and figure this one out. And please feel free to reach out to me. And like I said, I will be getting with Representative Gullett soon and talking. Thank y'all. This hearing is adjourned.